May I, Your Lordship? Your Lordship, I beg to mention item number 14, Your Lordship. This matter may be listed on this coming 19th of November, Your Lordship.
14th.
Yes, 1-4.
You're for the respondent.
Yes, Your Lordship, I'm fully respondent.
For the petitioner, you are for the
No,
petitioner.
I've taken concern, Your Lordship.
You have already come
Yes, Your Lordship.
to the consent of the others. The learned advocate so and so for the respondent. Read for an adjournment. On 19th, you want?
Yes, 19 November.
Let the matter be listed on 19th.
Oblige, Your Lordship.
I would like to mention item number 2. That his leading counsel is out of station, Mr. J. Gini.
JG.
Yes, ma'am. He's out of station, so I pray this matter may be listed after 2 weeks, my lord.
JG is out of station. The ground is in the ground. On behalf of Mr. B. Pitcher, great financial. Have you taken consent or have you
Yes,
informed
ma'am.
the other side?
Yes,
After 2 weeks.
after 2 weeks. Oblige.
If it may please Your Lordship, I beg to mention item number 22 on behalf of Mr. Disoki for the respondent.
22.
Yes. On behalf of Mr. Disoki
For the respondent.
for the respondent.
It's a contempt case, no?
Yes, Your Lordship.
Have you informed the other side?
Yes, Your Lordship. My Lord, may I pray that the matter may be listed after 3 weeks, Your Lordship. The leading counsel, Mr. Soki, is not here today.
This Soki is out of station. The ground, you mentioned the ground with the consent of the other side. After 3 weeks, you want.
3 weeks, Your Lordship. Much obliged.
May I please, my lord? My lord, I beg to mention item number 3 to 13. Matter may be adjourned for that and may be fixed after on 16th of December.
You are in all cases,
For respondent.
in all the matters, you are appearing for the respondent.
Respondent. On behalf of the company.
Several matters and the councils are also in most probably same.
Same, yours.
Feet of what?
Yes, Pitapur. We have taken consent.
Your good name?
M. Ratan on behalf of the Kamduk.
They come to.
Yes.
The Kamduk is not present today.
It's present.
One adjournment.
Yes.
3 to 13.
May be fixed on 16th December with the consent of the parties.
My lord, here, your lordship may clear one thing, my lord, because the land department has not yet filed the affidavit, my lord.
Land department.
Yes, so therefore it seems, my lord, they have actually earlier said they won't be filing, my lord. In some cases, they say they will file, my lord. So it may be made clear if they don't want to, your lordship will make it clear. They will not be filing
Land
affidavit.
department means land management.
Yes,
But the question is, land the Kamduk is appearing for land management or
land management.
for land management?
Yes,
For the
ma'am.
land management.
So are you going to file any affidavit?
Yes, we will be filing your.
My lord, that is,
Okay, we'll mention it.
my lord, since 2022, my lord, they have not filed, and they even said they won't be filing, my lord. Now in the last moment they say we will be filing, my lord. We will be,
So you are
if you-
representing the respondent?
for the petitioner.
Oh, sorry, petition.
Yes. Your lordship will see. They said they won't be filing.
Won't be filing now. This time he is saying that he will be filing.
I have to take Israel department.
Land management, land
Land
management.
management.
Yes, Mr. Kamduk is
Because
there.
we are confused now, my lord.
Going
My
to
lord.
file or you're not going to?
Yes, my lord. My lord.
No.
My lord, therefore, we are praying for fixing the matter on 16, my lord. In between, we will be filing our affidavit, my lord. Sort everything, my lord. Let it be last chance, my lord. Yes, my lord. Yes, my lord. For 3 years, my lord.
Mr. D. Kamduk, the standing counsel and management department for an adjournment in that context. Mr. Spencer, the land counsel for the petition submitted that the case is pending since 22 until that they are not filing any affidavit in opposition, and hence this prayer may be considered for the last revision. In view of that, the Standing Council for the Land Management Department, Mr. Respondent, Land Management is hereby asked to file their written statement, written affidavit in opposition, if any, on or before the last dates, next date of this. So we are listing it on 16th.
16 year. One more item, Your Lordship, that is 26. Item number 26, Your Lordship. Same year. Same time.
Item number 26 also you are appearing?
Yes, ma'am.
Item,
I'm for the petition, madam. No, respondents have not filed affidavit yet. Any of the respondents?
any of the respondents.
Yes.
So, Mr. Tapin, you are going to file your affidavit?
On behalf of deputy.
Government? You are for appearing for?
Respondent, Your Lordship.
The respondent.
Land
Yes,
Land
Your
management.
Lordship. On behalf of the company.
Submission of the bill. Okay. 26.
Madam, he will be for respondent number 1 and 2, madam. They
One
mentioned,
and two,
yes.
yes. And
For respondent number 4.
4, 3, anyone? is
3,
appearing for
Mr. Sakya.
Sakya is appearing for.
Sakya is not available, madam.
So, 1, 2, 3, 4, none of the respondents have filed their affidavit.
No.
Right, so hard so and so forth. From the office note dated 6/11/2024. And from the submission made by the Land Council for the petition, it seems that none of the respondents have filed their affidavit in opposition. List the matter accordingly. When they will be able to?
3 weeks.
After the-
3 weeks.
No,
You
Lordship,
want
the
any
matter
fixed date or 6?
of 16 already fixed, madam, other matters, madam. So it may be 16 December. Before that, let them file affidavit, madam. It will be more than 4 weeks, madam.
16 December, enabling the respondent side to file their affidavit in opposition if any. Okay, we have.
Yes,
16.
obliged.
Deeply obliged. My lord, I beg to mention item number 30, my lord.
Item number
30,
1, 3,
30,
3,
30,
3,
30, 30. My lord,
It's a
can it be,
supplementary hearing of 2018. What has happened?
my
Matter
lord,
is of 2018.
my lord, can it be fixed on 12th of this month, my
12 for?
this month?
Yeah. 12 to 13. 12 November.
Yes, yes, ma'am.
Huh? Can it be on 19 then?
Oh, okay then.
Maybe a bit difficulty on my personal account.
Okay.
19?
Yes, ma'am. In admission hearing, ma'am.
Yes,
In admission hearing, ma'am.
but it is for supplementary hearing, listed for supplementary hearing. Why in admission? Why you want it to fix in admission column? It is already in supplementary hearing list. Most probably matter has already been admitted.
Okay, my lord.
It will be on supplementary hearing itself on 19th.
Okay. Much okay.
At a request to answer for 19th. November. We are fixing it on 19th. Because it is of 2018 matter, try to.
Okay, much okay.
Your Lordship, may I mention item number 28? I'm for the petitioner here. We have to file, we need further time. Kindly,
File your
we have to file a rejoinder affidavit.
additional.
Yes, rejoinder. Kindly,
And the respondents said they have already filed their affidavit. in
Your Lordship, I'm appearing on for respondent 1 and 2. We have filed our affidavit, Your Lordship.
1 and 2 has already filed.
Yes.
And you are for? Okay.
kindly 3 weeks time may be given.
You are Mr.
M. Hambo.
Mr. Benson, the counsel for the petition, submitted that the petitioner side is going to file their additional affidavit and accordingly sought for some more time to file the same. Also heard NS,
Yellow, yeah, your lordship.
you're appearing for someone?
Yes, your lordship, senior counsel A Apang.
Appearing on behalf of senior counsel, Mr. A. Apang, for respondent number 1 and 2, and it is submitted that respondent number 1 and 2 has already filed their affidavit in information. Let the matter be when you need 1 week, 2 weeks,
3 weeks.
3 weeks.
Yes.
Let the matter be listed after 3 weeks, enabling the petitioner to file their additional affidavit and the respondents to file their affidavit in opposition, if any. So,
Right, obliged.
Hello. Lordship, I beg to mention long pending matter to be listed on 14th of this month. It is
what matter? What matter?
it's a SAO matter.
SAO.
Yes.
Court number 2, I think. Court number 2 is dealing with the SAO.
Lordship, court number 2 has just referred here.
SAO is not here, in fact, huh? Was it? Criminal matters, SAO, FO are dealt by the court number 2, I think.
Alright. So, see,
Okay, we'll make it, I will confirm it to court. He will help you, whether you,
yes.
if you want to mention it on the 14th,
Yes.
I will try to accommodate, because we are not dealing with these matters, that's why I thought that the matter may be mentioned before court number 2. We'll try to mention it.
Oblige.
May I please, Your Honor?
Yes.
This petition has been preferred by the petitioners under Article 226 of the Constitution, challenging the impugned order dated 19 September 2024, that is annexed at page number 19, Your Honor. Page 19,
Page number?
19.
19.
Now, by way of this transfer order, Your Honor, the petitioners herein who are from 1 to 8, they have been transferred. Your Honor will find the petitioners at serial number 52, 53, or 52, 54, page number 20, Your Honor. Serial number 52, 54, 55, 56, 57, 58, 59, and 60.
How many petitions are there?
8 petitioners in total.
I can see serial number 50, 30,
52,
30, 32.
52, page 20,
52, Mala,
Okay,
52,
52,
20,
52,
page
yes,
20.
52,
53, or 54, sorry, 54. Thereafter from 54 till 60, Your Honor.
54 to 60.
Total 8.
Okay.
Now, Your Honor, this transfer order has been challenged by the petitioners in view of the teachers' transfer and posting policy that has been released by the Education Department, which has been annexed at annexion number 3, page number 41. Now, in view of this particular policy, Your Honor, at page number 41, Your Honor will see that there are 2 types of transfers that can be made. One is administrative transfer and the other is transfer on request. Now, this particular transfer it appears to be an administrative transfer because no request as such was made on behalf of the petitioners. So administrative transfer can only be made in case of exigencies of service and in public interest or on administrative grounds. However, in this case, Your Honor, it is found that the petitioners were transferred from their posting only on the basis of a UO note that was sent by the MLA of the particular constituency. And the said UO note can be found at page number 21A of the petition, Your Honor.
30,
Page 21A.
Hmm.
Page 21A, if Your Honor will see, The names of the petitioner will be found at serial number 1, serial number 3, 4, 5, 6, 7, 8, and 9. These petitioners were, if I may read the order, Your Honor. The Honorable MLA has said that it has brought to my knowledge that all the teachers mentioned below are not sincerely doing their duties and therefore causing a huge hindrance for the students. The duty of teacher is to so and so, so and so. And then as the matter of above facts, the Honorable Minister Education, Government of AP is therefore requested to kindly transfer the above mentioned teachers in the interest of public with immediate effect. Now, if Your Honor will see, very interesting fact here is that the respondent number 6, who's the MLA herein, he has also mentioned the place of transfer posting herein. He has mentioned that the petitioner should be transferred in Changlang, Tirap, Longding district, which are in the easternmost corner of Arunachal Pradesh. Now, coming to the grounds of this writ petition, Your Honor, why this order has been challenged herein, is that first of all, as it has been mentioned in the transfer policy of the Education Department itself, that transfers can only be made during administrative exigencies. And in the transfer order itself, it is not mentioned anywhere that there was an administrative exigency or in the interest of public, the particular petitioners were transferred. Moreover, if the petitioners were transferred in these particular districts, in place of their posting, there were no other teachers who were posted. So their post would remain vacant. And this particular time is at this point, Your Honor, the schools are going through mid-academic session. So during this time, if the petitioners are transferred, the students will also suffer irreparable loss. If I may also take Your Honor to clause 8 of the transfer and posting policy at page number 43. 43. Clause 8, Your Honor, transfer calendar. Herein it is clearly stated when the transfers can be made. In case of general transfers, it will be made only once in a year as per time schedule given in para 8, clause 2 below. Now, according to clause 2, Your Honor, only in the month of 1st of May to 15th of May, online processing of applications through transfer posting software and issue of transfer orders can be made. And by the month of 16th May to 31st May, disposal of all transfer-related cases and processes should be completed. Now, if we look at the transfer order herein, the transfer was made on 19th of September 2024, which is in complete violation of this particular clause of the said policy. Also, Your Honor, it is an accepted principle that the transfer of a public servant is an incident of service, and the authorities have the discretion to transfer their employees in whichever places they wish to. However, if in case such an action is not bona fide and it has been done due to an extraneous consideration, which in this case is because of the consideration of the MLA, that transfer, he has particularly mentioned the name of the petitioners. In such a case, such an order would result in malified exercise of power. Hence, this particular transfer order is liable to be quashed and set aside.
The ground they be here not by the MLA.
Yes,
You are not working properly there. That means the main reason, because maybe there may be complaint against you, I think.
yes, Your Honor. But even in that case, if the petitioners are not functioning properly, there is a procedure that can be taken against them. This disciplinary inquiry can be set against them, but the transfer order cannot be a penalty for them not performing properly. And moreover, such a complaint has never come from the student side or from the department, from the education department. The MLA has just written this particular letter. However, there's no evidence as such to back his contentions. So today, Your Honor, notice may be issued, and in the meanwhile, the transfer order may be stayed until the next returnable date.
Malad,
Seems that the transfer order has been made only on the basis of the note by the MLA.
Malad, in that case, Malad, we required to file the affidavit, Malad, on the what is the exactly there on the ground and in the records, Malad. Notice may be issued, Malad. And the Malad, in this connection, of course, Malad, so many litigation they have filed, Malad, in other cases also, in the connected similar cases, Malad. We'll be filing the counter, Malad. We are short for the Paraguay's comment, Malad. This challenging same this transfer order, Malad. We'll be filing, Malad. Notice may be issued, Malad.
In regards to state
I beg to submit two orders of this honorable bench as well, wherein similar matter was taken up and the interim was continued, Your Honor.
reliever is not yet posted, I think.
Malad, not it. No reliever, Malad. Reliever is not there. We sought for Paraguay's comment in other cases also, Malad.
In other cases also.
Right.
One is she submitted, one is WPC 497
Yes,
2024
ma'am.
is also there.
Around more than 10 cases, they approached Malad, challenging this same, man.
Heard MS
B.Y. Bhutia.
T. Y. Bhutia, the learned counsel for the petition. And also heard Mr. T. Takum, the learned standing counsel, education department, representing the state respondent number. So you are basically representing
Malad, 1 to 5, Malad.
all.
Respondent number, yes, all, except private respondent, Malad.
Phone number 1 to 5. So and so. This is an application under Article 226 of the Constitution of India for issuance of writ. Constitution of India, challenging the legality and validity of the transfer order by memo number EED dash 10212 bracket of 11 slash 8 slash 2024 dated 19/9/2024 and signed on 10/10/2024. Issued by the Commissioner, Record of Education, Government of Arunachal Pradesh, whereby the petitioners have been transferred from Siang district to the disposal of DDSE, Longding, Changlang, and Khunsa. Issue notice provided to respondents. No formal notice is required to be served on respondent number 1 to 5. However, extra requisite copy of the petition may be furnished to the respondents during the course of the day. Heard on the next prayer, heard on the interim prayer. It is submitted by MS Bhutia that the present transfer order has been made in the mid-academic session, violating the transfer policy of the department concerned. Especially violating the clause 4 and clause
8.
Clause 8 of the said notification dated 10/2/2022 issued by the Government of Arunachal Pradesh. It is submitted by Ms. Bhutia further that this your 8, na?
Pardon,
Eight
ma'am?
numbers,
Eight
eight
petitions.
numbers of petitions has been transferred from their previous place of posting only on the basis of your note by the concerned MLA and concerned MLA poster. However, there is no reliever has been posted against the post of these petitions. Accordingly, she submitted that till the disposal of the so and so, the transfer order dated 19/9/2024 may be stayed accordingly posted. Next one, Mr. T. Tagum, the learned standing counsel, education department submitted in this regard that they need some more time to file their affidavit in opposition as a similar kind of petitions are also being filed against the transfer order by other petitions, by other teachers. Poster. Next one, considering students for state political. Till next step list. So we are listing it after 3-4 weeks. 4
Mal-
weeks will need.
My lord.
4 weeks when so, enabling the respondent file their affidavit in affidavit of opposition. And you take steps for it too. Till
Respondent
then, we
number
are
6.
stay.
Deeply obliged.
Deeply.
My lord, in this case, my
Fixed
lord, this,
matter, no?
yes, my lord, they have been running away from this case, my lord. My lord, this matter may be dismissed for non-prosecution, my lord. On 23/10.
Wait.
Yes, sir.
Come out of who knows that? Huh? This one. Oh, yes, he is appearing.
15.
1-5. You are appealing for 1-5?
No, my lord.
How about a deed of now?
My lord.
Only last occasion he was present. that's
Yes,
why I
my lord.
put that,
My lord, on 23/10/24, my lord, also the petitioner was, my lord, was absent, my lord. Lord, what happened, my lord, due to pendency of this litigation, my lord, department is facing a problem. my lord. So we have raised the locus
They
standi.
also you have submitted, so
Yes, ma'am.
that's why the matter has been listed.
Yes, my lord. My lord, this matter may be
Just for time being.
dismissed for non-prosecution, my lord. If they are interested, my lord, they can file IA, my lord, for restoration, my lord.
That's for time being.
My lord.
Your Lordship, here also on the last two occasions, petitioner was absent, Your Lordship.
That's what we do.
On the last two occasions. Your Lordship. Extra copies also they have not served to us. Your Lordship.
You have not received the extra copies also.
No, Your Lordship.
Please say that, please. RMS Arbasa, the London Government Advocate. We accordingly submitted, no extra copies have been furnished to the respondent till date. Also, none appears on call for the petition. From the record, it is seen that in the last two occasions also, the petitioners remained absent on call. However, for the use of justice, one more chance is given. In default, consequential order will be passed. List accordingly after 2 weeks. We're listing it after 2 weeks.
No,
If they
sure.
remain absent on the next day,
Lordship.
consequential order will be passed.
Lordship.
May I please, madam?
Yes.
My lord, here I am appearing for respondent number 3 and 4, my lord.
You have
I'm sorry,
filed till
I'm
9.
for the petitioner, my lord.
My lord, as for my instruction, my lord, we have already sent a complaint to the competent authority, my lord, because it is a FIR filed before the SIC, my lord. So under the mandate of 17A of the PC Act, my lord, we cannot investigate or inquire into the matter unless we have been approved by the competent authority, my lord. Therefore, my lord, on 8th of March, we have already sent the file to the competent authority, my lord, for approval, my lord.
8th of November. For
No,
approval.
8th of March.
8th of March.
Oh, 8th of March.
But we are yet to receive any approval from the concerned authority, my lord. As and when we received a approval, my lord, we'll carry out with the preliminary investigation.
So this writ petition is basically for
Non-registration of the FIR that has been
non-registration of the FIR.
FIR.
It's a it's corruption matter.
Corruption.
Corruption.
It's been taking us too long for the approval since 8th of March, my lord. We are in the month of November now.
Yes, obviously.
There is a, but then, my lord, since there is something which the government can answer, my lord. We are just the investigating authority, my lord. We are
So
handbound.
whatever, till now, the matter has not been registered due to non-receipt of any approval from the department.
My lord,
They have not initiated the preliminary inquiry. As
Inquiry.
per the mandate, they have to initiate the preliminary inquiry as it is a corruption matter.
Mm.
But that preliminary inquiry has also not been initiated because there is no approval, as has been said. And this approval has been pending since March. In the last occasion, this honorable court gave us 4 weeks time to give the updated status. But there's no update, I guess.
no, I have received the instruction, my lord. Therefore, we have
You received?
the instructions, my lord, from the respondent number 3 and 4, my lord.
Respondent 3. Possibly, my lord, the respondent number 2 who has to make the price the court regarding the approval. Why they are taking so long for?
Yes, Mr. Tappan.
Lordship, can you take instruction, Lordship, what action has been taken from the on respondent 1 and 2?
That we cannot say, but now here it is seen that as per commission from Mr. Pada, they sent for the approval for on 8th of March 2023. And one order is there on 4/6/2024 order. On that day, there was no instruction, but I don't know till now why it's not been initiated or related to Buzi Paison.
Instruction,
You want to take instructions in the because that seeking approval letter is pending since March. Now it is November. So that's why. Heard Mr. B. Kaushik, the learned counsel for the petition, and also heard Mr. S. Tapin, the learned senior government advocate for the respondent number 1 and 2, and Mr. Pada, the learned standing counsel vigilance for the respondent number 3 and 4. It is submitted by Mr. Pada, counsel for the standing counsel of vigilance for respondent number 3 and 4, that they have already sent letter for requesting for the approval for registration for initiation of the proceeding of this case on 8/03/2024, but till date they have not received any instructions from the competent authority. Mr. Tapin, the learned senior government advocate, submitted in this regard that he will take instruction in that regard and sought for some more time for the same. Yes, now it is already late, so when it can be posted?
Lordship, 10 days time.
10 days. 10 days hole kiman?
18.
17.
18. Can it be 18?
17 is Sunday. 18.
18 or 18 blocks many matters have been fixed. I think 19 material be on 19.
My lord.
19. So and so enabling the government enabling the responding side to take instructions from the competent authority regarding the approval of regarding the approval. Okay,
Great.
we're fixing it on 19 September. Take instruction.
Okay, sir.
Oh, 15, yes.
Right.
Yes.
Lordship, here in this case, the purpose of filing this writ petition is somehow served, fully served. the authority, the concerned authority who sanctioned the scheme has cancelled the scheme. So my purpose of filing this writ petition is fully served.
Authority
So
has cancelled the scheme.
cancel the scheme. So I'd like to withdraw this petition.
We want to withdraw.
Yes.
Without any observation, my lord.
And we are not going to observe it.
Yes, my lord.
As you want to withdraw is because authority has cancelled.
Yes.
No, my lord, that
Yes.
my lord, observation not be made, my lord. Because we will be challenging their locus, my lord. Because subsequently, if we rectify that, my lord, they will again file a writ petition, my lord. So why, my lord, no observation may be made, my lord. Simply, they may be allowed to withdraw the writ petition.
Okay.
My lord, here in this case, we panchayat, elected panchayat, there were 14 panchayat. And within 14 panchayat, one video block development officer who is office secretary, panchayat office secretary. This scheme to be implemented by the video with the consent of the panchayat. But here in the case, 41 number of scheme proposed by the video to implement it within the territorial local jurisdiction of the panchayat without any information, without any suggestion from the panchayat leaders. This video is proposed to implement 41 number scheme where there are no human settlement. Any scheme is sponsored by the either state government or central government is to be utilized in public utility purpose. Here, for that we submitted a complaint, but consent video did not initiate our complaint. For that numbers of complaints we submitted before the video, before the deputy commissioner, before the concerned director RD. No such consideration of our complaint. Therefore, we have no option and file this writ petition. Accordingly, this Honorable Court why not
After filing by writ petition, the authority has cancelled the
cancel?
schemes.
Yes.
Okay, in that case, will not make any observation. Is there any other prayer for you for? No. Heard Mr. T. Soon, the learned counsel for the petition, also heard Mr. B. Picha, the learned counsel representative respondent.
1, 2, 4.
1, 2,
And 4.
1, 2, and 4. And Mr. Y. Iram, the learned government advocate, appearing for a respondent number
3.
3. The case was listed in admission column. However, it is submitted by the counsel for the petition, Mr. Som, that he is not going to raise the petition further and wants to withdraw this. In considering the submission made by the counsel for the petition, the present writ petition is disposed of according on withdrawal. Okay.
My lord, much observed.
Obliged.
Not T son, Tar Torum, my lord.
Sorry.
T Torum, my lord. T Torum.
Oh, sorry, Tito.
My lord, my submission may be kindly noted because the purpose of filing of this writ petition purely served. It may be
No.
Then okay, then I will not go by this. You have your submission may be recorded that the purpose of filing the writ petition has already become infructuous. That can be recorded. Otherwise, he has objections some
Yes, ma'am.
that in regards to cancellation of the schemes and all, so that part can be recorded.
Yes, that
It's submitted that he wants to withdraw this and so as the purpose of filing the writ petition has already become infructuous.
Yes.
May I please, Your Lordship? Your Lordship, I'm appearing for respondent number 1, 2, 3, 4, and 5, Your Lordship. We have filed our affidavit for respondent number 4 and 5 already. However, Your Lordship, we need some time.
You are appearing for 1, 2,
2, 3, 4, and 5.
4 and 5. 4 and 5 we have already filed.
4 and 5 we have already filed, Your Lordship. However, Your Lordship, we need some more time for 2 and 3.
2 and 3.
Yes, Your Lordship.
Your Lordship, I am appearing for responding number 6.
For 6. And 6 you have filed your?
Yes, already filed.
Already filed.
Your Lordship, may kindly grant 3 weeks time for filing our affidavit, Your Lordship.
Now, this petition is also connected with some other content matters. Content cases are also there, 1, 2, 3.
Content case between 5
You didn't do Same order in one here, contempt. The contempt is pass as separately for. You can find same.
One to CSM.
So petitioner's name is.
Land departments.
So heard students. And also heard MS Sangeeta. She is Sangeeta. Sangeeta for the comment advocate for respond number 1, 2, 3, 4 and 5. And also heard Mr. Swenso for the respond number 6. It is submitted by MS Sangeeta that they have already filed a affidavit in opposition for the respond number 4 and 5. However, she needs some more time to file the affidavit in opposition for the respond number 2 and 3. The council for the respond number 6 has also submitted that they have already filed their affidavit in opposition for the respond number 6 for affidavit in opposition. On next para, considering the submission made by the Darling comment advocate, so and so, let the matter be listed. How many weeks you need?
3 weeks, Your Lordship.
That will be listed after 3 weeks, enabling the respondent to file their affidavit in opposition. List the matter along with contempt case number. You keep all the case number. There are 3 contempts will be listed together.
Yes, yes.
Obliged.
Like.
Service report regarding respondent number 7 and 8 is still await.
7 and 8.
Private respondent.
They're private respondent.
Yes.
When did you take steps for respondent, private respondent? I think on 7-3. Oh no, it is awaited since long, I think.
And I may be allowed to take fresh step.
Take first steps then.
Yes, sir.
Otherwise, it is awaited for. Have you taken these steps to dusty mode? No.
This,
Will be allowing your dusty service also.
yes, sir.
Because it is pending, it seems that in the month of January only you have taken steps. And since then, it is still pending for, it's awaiting service. You have filed your
Yes, 1 to 5, we have already filed.
affidavit in opposition also
Yes.
filed? You are appearing on behalf of, your name is here?
Yes, my name is Dirimi.
Huh?
Dirimi.
Yeah,
Family yes.
Hassan. So and so. For the petition, and also hired Mr. Peter, standing counsel, WD, representing the respond number 1 to 5. And it is submitted by him that they have already filed their affidavit in opposition. However, from the service report, okay, office note, it is seen that the service is still awaited for respond number 7 and 8. In that context, MS so submitted that they may be allowed to take fresh steps in the respond number 7 to 8. Where allowed, full stop, the petitioner will take steps on the respondent numbers 7 to 8 to registered post and dusty services also allowed. Which will be looked at today, SGCC put on this. List after 3 weeks. Takes steps immediately for respond number 7 and 8, private respondent. And also take steps to dusty mode. We are
Yes, sir.
3 weeks, after 3 weeks.
Bless you.
Your Lordship, I'm appearing for the petitioner. For petitioner? Yes, Your Lordship.
Your Lordship, I'm appearing for respondent number 2, 3, and 4. And we have filed our affidavit, Your Lordship.
2, 3 and 4.
Yes, we have
You
already
already
filed.
filed your affidavit?
Yes, Your Lordship.
Now. Who is one in fact?
One is land management, Your Lordship.
It's
Name
then management was there. Okay.
Commissioner Secretary.
2, 3, and 4. 5 is private respondent.
Yes, I am appearing for respondent number 5.
5.
Employees are there.
You have filed your
Yes,
affidavit in
Yes,
opposition
already.
also?
in the month of July. Yes.
Okay. Yes, then if you want to argue the matter or it may be
We would like
listed
to
for
file a
hearing.
rejoinder.
Huh?
Rejoinder. We will file rejoinder.
You want to file rejoinder?
Yes, Your Lordship.
Yeah, Miss Gogoi,
And only.
heard so and so. The counsel for the petition and also heard Ms. P. Sangeeta, the learned comment advocate, appearing on behalf of respondent number 2, 3, 4, and 2, 2, 3. 2, 3, 4. It is submitted by her that they have already filed the affidavit in opposition. Also heard Mr. So, the counsel for the respondent number 5, private respondent number 5, who has already filed his affidavit in opposition.
There is an interim,
However, it is
Lordship.
submitted by MS so that they wants to, the petitioner will be filing the affidavit of 100 and accordingly so some time for the same. Prayer allowed. How many weeks you need?
2 weeks.
2 weeks. Let the matter be listed 2 weeks. Your interim was.
Yes, Your Lordship.
Till then interim be continued till next date of it.
Be obliged.
My Lordship, Lordship, here we need to take instruction from our client. So therefore, I pray, matter may be released after 1 week.
It's a contempt case.
Yes, yes. I'm for a petitioner.
Is there any steps taken by the department, Mr. Tapu?
Lordship, I am for a respondent number 3, Lordship.
3.
A. And 3 is not necessary party.
Is there any payment, etc., or implementation?
That part, Lordship,
You're for 3.
3.
3?
Newly implemented party, Lordship.
Oh, newly implemented party.
Newly.
YW Ringo. It's a private. Oh, what?
Private Lordship, contempt matter, Lordship. As a private counsel, I'm
Oh, you're
appearing.
private. That's why.
It's a contempt matter, Lordship. By name, all are
That's why Lordship, we
So
will.
you are for 3.
3.
Principal Secretary Finance is 1.
1.
Do by name, in fact. Yes, you want to take instructions.
Yes, yes. So therefore, the matter may release for 1 week, after 1 week.
Instructions from
From client, our client.
from your client.
Yes, yes.
On last earlier 2 occasions, Lordship, during the course of hearing, the petition was advised to implement the Secretary Planning and Investment because the fund allocation is being made by the Planning and Investment Department. And so far, respondent number 3 is concerned. They are from Finance Department. Until unless fund is allocated by the Planning and Investment Department, Finance Department cannot do anything. So on last occasion also, they have been advised to implement the planning, Secretary Planning and Investment Department. So they were supposed to take necessary steps on that furloughs, but they are not doing anything. I think they are asking time for.
He's taking, I mean, you can do this way, otherwise. You are Mr.
L Rakab.
So and so for the petition, also heard Mr. S. talking for the appearing for the respondent number 3. It is submitted by the counsel for the petitioner, contempt petitioner, that he needs some more time to take instructions from his client. From the petition. Prayer allowed, list matter. You want 1 week or?
Yes, 1 week.
1 week, list matter accordingly 1 week. And I bring the counsel for the petition to take his proper instructions. Okay, we're listing it after 1 week. Take instructions.
Obliged.
Place the instruction before the court. We'll
Yes,
pass it
yes.
on. Yes.
May I please once. My lord, service upon respondent number 4, 6, and 7 is still awaited, my lord. My lord, I may be permitted to take justice service upon them. my
4,
lord.
6, and 7 is awaited.
Yes, my lord.
Four, 6, 7. You're for private respondent or
I only implemented respondent
number?
number 9.
It's a private respondent.
Yes, ma'am.
And you're representing 1, 2. Mr. Tapi, you are
1 to 3 laws.
1,
1 to 3.
1.
Hello, this is a tender matter laws here. Because of this pendency, the work is just different. It was filed in 14 March.
4, 6, and 4. You are 4, 7, and 8, na?
4, 6, 7, ma'am.
4, 6, 7. Who are 4, 6, 7? They are also private respondent, I think.
Yes,
They are
ma'am,
private
private respondent.
One is from district Alu, Lysian. For trustee, trustee allow.
Then short that may be given because my friend is going to take
Bring for
justice service.
trustee.
Yes, ma'am.
Then, as per you, when it can be.
Well, so I will take justice within 7 days,
In
ma'am.
2 weeks, at least 2 weeks.
2
or
weeks time.
2 weeks, because he's.
Yes, ma'am. Yes, ma'am. I understood.
Yes. 2 weeks time. When so appealing for a private respondent number 9, 4, 6, and 7 only justice. We are allowing justice for 4, 6, and 7.
My lord.
Can it be fixed on 20 laws? 20
You do want date fixed?
Yes.
28th of November.
November.
It will be 2 weeks.
It will be 2 weeks.
Okay. Okay, then we are fixing on 20th November, 20.
20.
My lord, let it be on 26, my lord. Because, my lord, I have to file, my lord, the return affidavit also, my lord. Because after,
Otherwise, 23, 24, 25 are holiday.
yes, my lord, that's why, my lord,
Why it is holiday here?
that 25 is
23,
holiday.
24 is okay, holiday.
Otherwise, here in this case, our affidavit is the main affidavit, our stand.
Huh.
We file our affidavit on 2nd of May already. Therefore, may not be necessary also. Private respondent, what they can say, nothing. But as a formal lawsuit,
Yes, ma'am. What, well, since there is private respondent, my lord.
let the matter come on those 20. Then if they comes up, then they may not come up also.
20 or 21, it can be.
My lord, 21.
21?
21, no.
21, 11.
Obliged, ma'am.
Yes.
Well, my friend was to bring an instruction with regards to page 108, the impugn order. You give the extra copy. After my friend submits, Miller, I am going to argue on merit, Miller.
So, this is the record. I mean.
Yes, my lord, one of the allegation was that executive of that division was kept out of the inter-tender process. That was the allegation. From the record, technical bits, there is his signature. Entire uploading was done by the executive engineers. So there is record to show that he was very much part of the tender process. So that very submission made by the petitioner itself was misleading statement. And misleading before a statement made before this honorable court is sufficient ground to dismiss the writ petition. And regarding the case, ground on which his tender was rejected, a technical bid was rejected. There is two documents. That is 4.7 clause 2.
Yeah, for
Recorded notice which he issued to him.
no, where from you see 4.7? Oh, in the from the petition.
Petition. 4.7, that is page 42 of the his writ petition.
Correct.
Yes, 4.7.
The record of work performance such as abandoning the works, not properly completing contract, inordinate delay in completion, litigation. This is inordinate delay. He was awarded some other project in the year 2019, same PMG's road, same division. So till today, in his bid document also, he has shown that it's ongoing, that same project, very project. And regarding, in spite of giving 2-time notice, he could not complete the project as per schedule. Said project was supposed to complete by 2021, but till today, now as per his ongoing commitment document which he submitted, he has himself admitted that this project is going to complete by December 2024. That is his document in the
December.
and December 2020, he is assured to complete that project, 2029 project by 2024.
That was the other project.
The other project. That is, there is a, that itself is a reason to reject the tender process. 4.72. If there is delay in, inordinate delay in, there is a 2029, now it's 2024, there is inordinate delay. And regarding tools and machinery, the evaluation committee has found that the same tools and machinery which is engaged in that ongoing project, same machinery is also punished in this tender process. That is why he's one of the other ground for rejection of his bid was regarding tools and machinery, insufficiency of tools and machineries. And then another ground which he was rejected is the demand draft which he have submitted on 11/7/2024. Now, during the date of opening of the technical bid, by that time it's already 3 months expired. He has to revalidate that demand draft. It was already delayed. So he is supposed to revalidate it. He has not done that. So in view of the, my lord, there is sufficient ground to reject his technical bids, and time and occasions, the apex court on many cases, in catena of cases, and has stated that if the tender is rejected arbitrarily without any reason, malafidely, then in that case, there can be court interference is called for. So I'm submitting some of the principle when it can be challenged, how it can be, when it can be interfered, where it should not be interfered. Gist of the cases and grounds. And my lord, in some of the cases, even if there is some irregularities, court has to restrain interference. Since this is a public interest project, these roads is going to connect a village inhabited by Purohik, one of the underdeveloped or one of the backward classes of the Purohik, my lord might have heard, Purohik. Till recently, they have been free from the bounded labors. So this project will cover their village. Till then, after 70 years of independence, this village is not yet connected. And this is very important road which will connect Purohik village and to international border. And this is Vibrant Village project is a project which is given only to border areas, international border with China. All the villages which is not connected, situated within the international border, has to be connected by these projects. So this is very important project for sake of 1% or 2%. The public interest project cannot be stalled. So the entire population of that village, they are supporting the farm who are going to execute the work. They are in favor of the executing the work as early as possible. So some few persons, they are trying to derail the progress of the development activities. Even I don't know that the authorized letter, whether it was given by the proprietor of the farm or not. I have a doubtful. So it may also require some handwriting test. Nowadays, there is several instances where the owner of the farm, proprietor of the farm, they did not authorize, but they made some authorization letter by themselves and they filed with petition. Later, and they has to withdraw the petition. Such incidences are also there, my lord. So in view of my humble submission, this petition is liable to dismiss on merit also. There is ground for rejection of his bids, sufficient ground. And now my learned friend is trying to turn the situation by taking advantage of that conversation between the executive engineer. This also happened if during this period also, before awarding or he was not supposed to have a contact with the tendering authority. That itself also ground for rejection of the bid. There is condition is there. So he has made a contact with the executive engineers and he has provoked. In the matter, executive engineer has said something and he is trying to taking advantage of that situation. Such conversation has no relevance at all. This case, my lord, petitioner has to establish the ground on which his technical bid was rejected was illegal, arbitrary, and he has fulfilled all the ground. Even the tools and machinery, there is no document to source other than some lease document, a list of the tools and list of tool document can be submitted by any person. It is with that he has to submit a supporting document that I have such document, registration number, then insurance number of the vehicles. He has to submit only the few lease deed without any registration number, insurance of that vehicles. So how the tendering authority will know that he have possessed? So in view of this, writ petition itself shows that he could not substantiate that he have sufficient tools and machinery also, which he cannot annex, even it is not annexed in the writ petition. So my humble submission, this is a public interest project. This writ petition may be dismissed. So few interested person cannot hold the developmental activities.
My lord, my friend, as usual, in his own honesty, comes up with this kind of argument in tender matters. Well, the practice and procedure, my lord, it demands this court cannot accept a piece of paper without being submitted before this court in the form of affidavit by means of oath. That's why, my lord, my friend has rightly said, my lord, that word, it happens. The literal meaning of it happens means, my lord, something has really occurred. Yes, fairly admitted, yes. There was a fraud. Vitiated fraud, mala fide, biasness, only to favor these two private firms. That he has demonstrated, he has agreed by his own statement. It happens. In a official procedure, my lord.
I am not admitting. I am saying that he is trying to take that situation
No.
as submitted by himself yesterday and in his writ petition.
No.
I am saying that, I am not admitting.
No, my brother, you just take it in a literal interpretation of the word. It happens, Milord. It happens means what? Really, there was a fraud. And fraud has occurred. How an executive engineer can have a conversation with the bidders, Milord. And then to justify or per se, Milord, to fortify my argument, that is why that section 63, Milord, BSA, Milord, that 65B of the old Act, Indian Evidence Act, certificate was given. If that is false, then immediately I am liable for a prosecution under perjury or misleading. The law is open for you. You have not done. That is one aspect my lord will kindly take. Secondly, my lord, all his contention falls flat for one reason, my lord. Where is your instruction?
I understood.
My lord, 108 of my read petition, my lord. That is the impugn order, my lord. My brother has come with fully charged today. So I think like I should able to demolish this case, my lord, from here on. My lord, I have pointed out yesterday how the bid is to be opened. My lord will kindly come to page 48 of my read petition, my lord. And from here, I will demonstrate my case, my lord. And pertinently, my lord, my friend has not given the justification on this particular point. Simply made a statement saying that they have not fulfilled this. No, my lord. Actually, like tender document is authored by the executing agency. Being an author, they knows the nerves of a bid process, my lord. And these bid process, my lord, how it ought to have been opened was, kindly come to page 49, my lord. That's bid opening starts from of the NIT, my lord, that clause 22. And then, my lord, we'll kindly come to page 49, next page, 22.5. Now he has no answer to this. I'm sure he cannot give this justification, my lord. And my lord, secondly, before reading this, on record, I am making a statement. Why all the tenders evaluated by the chairman come SE of this particular circle is always put under challenge before this honorable court? Is only because of these, my lord, they are master in interpolating the records, forced manufacturing, and this exactly has occurred, my lord. I'll demonstrate. My lord, kind of 22.5, I'll say. Evaluation of part 1 of bids with respect to bid security, qualification, information, and other information furnished in part 1 of the bid in pursuant to the clause 12.1 of the ITB shall be taken up and completed within 5 working days of bid opening. Now, my lord will kindly note, 15/10/2024, the bid was opened. This has not done. He has not given the justification. When, my lord, there is a law which says when a statute, my lord, in statute, my lord, two kind of rules are framed, my lord. When we looked into the interpretation of the statutes, my lord, one is statutory rules and another is a normal rules, my lord, to enable the act to be implementable, my lord. Here, my lord, in this tender bid, my lord, when terms and condition is set by the employer, they ought to follow in a spirit, because this is the Bible for them. They cannot go away. This is an statutory one, my lord, because the vibrant blaze program, my lord, is brought under the guideline used is under the PMGSY guidelines, my lord. Here it says, when a particular statutory act asks a particular authority to do a particular thing, you ought to do in that particular manner, not otherwise. So here, my lord, how they have violated, my lord, kindly see 26, my lord, to 22.6, my lord. The results of evaluation of part 1 of the bid shall be made public on e-procurement system, of following which there will be a period of 5 working days, during which any bidder may submit complaint which shall be considered for resolution before opening part 2 of the bid. Now, my lord, kindly see 1510. And, my lord, the notification was issued on 28, and it was uploaded in the portal on 3rd of November. Therefore, my lord, the entire process is murky. This action of the respondent authorities, especially the superintending engineer come chairman of the bid evaluation committee, is prima facie on face of the record, my lord, is actuated with mala fide, bias and arbitrariness. What my brother was pointing out, that without making allegations on the arbitrariness, this thing, even if there is a small procedural mistakes, tenders process should not be interfered by this honorable court in exercise of power under 226. My lord, the law, I am making it very clear. I will be coming to that judgments, my lord. The first law is the Tata Cellular, my lord. Tata Cellular paragraph 94, I'll come to that, has clearly laid down the law. Normally, the reed court should not interfere in the tender matter, unless, but equally, the law is well settled if the decision making is biased, actuated with the mala fide, and there is an arbitrary exercise of power, then this honorable court has a power to examine the decision making process. Because neither this court nor we as a council, we are expert technically, my lord. We only see the decision making process. So that's why, my lord. Then to 22.7, my lord, kindly come. The 26 is most important, my lord, that already I have read. 22.7. 6 earlier. My lord, 6 also referred to, I have referred to. 22.7. The engineer shall inform the bidders, and now I am coming to this, how this was not. The employer shall inform the bidders who have qualified during evaluation of part 1 bids of the date, time of opening of part 2 of the bid. If the specified date of opening of the financial bid is changed, in the event of a specified date being declared a holiday for employer, the bids will be opened at the appointed time and location on the next working day. Now, my lord, kindly see, in one of their records, my lord, in one of their records, which I would be coming in the form of additional affidavit, my lord, they said the tender was Rupa, my lord, it is in the West Cumming district. And Sapa RWD division, my lord.
We are going to file any addition here?
No, I will have to file, my lord, because it required me. The tender was supposed to be open, my lord.
I'm just, I'm asking you.
No, ma'am, no.
Otherwise, I'm
If
going to
required,
hear the matter.
no,
Will be
no,
any addition?
no, required be, my lord, I will file, I said. No,
Then
required be, no,
don't
I'm
hear the
arguing
matter
on the
of
merit, I'm arguing on the merit, my lord, not required. Yes, my lord,
Stop.
miscommunication. No, tender was supposed to be opened at Rupa, my lord, the circle headquarters. The tender was open here. And there are also a prima facie information that I got. The executive engineer was not there on that day. Number 2, my lord, the additional deputy commissioner, ADC, Rupa, who was one of the board member, was also not there on that day, my lord. And then, my lord, kindly see when there is a minutes being prepared of technical evaluation board. In that case, my lord, then and there it has to be issued.
Instead of Rupa, where it was.
Itanagar.
Done.
That I am consulting one IT expert also, my lord. From the domain number and the computer number where it was opened. That part also I am getting the information, my lord. In any case, my lord, since 1990, I am using computer MS-DOS application that I know. IP address I locate. My lord. So therefore, the tender was open here. And then, my lord, see, it is 28 October, my lord. And it was uploaded, my lord, have his instruction, my lord. No, what's that? No. Same one? He has given me in piecemeal. Okay, this is? No, more that. Where is that our mistake? Tata Ojo Park, separate. My lord, we kindly come to serial number 6 of the technical beat, my lord. That is the reason why I said they are master in forging, manipulating, fabricating documents. The evaluation, my lord. Evaluation of bids.
Item.
Well,
Which
there's
bid? Oh,
which he has provided serial number.
Serial number?
Serial number 6, evaluation of bids.
Yes.
The evaluation of the evaluation committee examined the bids to determine the responsiveness, details of checks made in this regard to determine compliance of the bids with the qualification requirement are detailed in attachment 3. My lord, kindly mark this. Normally, it is not done. Never, my lord. I have done more than 300 tender matters, my lord. I have seen lot of technical evaluation board minutes. The answer is given then and there on that day only. One of my main specific aversion contention is that on the same day, these people have not given us. But it is only after, my lord, kindly say 13 days, and then my lord will take another 28. 15 to 13 is 14 days, my lord, for 13 days. Then another 3 days, then 16, my lord. 16, then the month ends, then another 16, then third, my lord, another 3 days, 19 days. In 19 days, they have successfully fabricated all those documents, manufactured. What imperated you not to assign the reasons handed out in the presence of the bidders? My lord will kindly see the conversation at page 198. Between the executive engineers and the petitioners here, my lord. Prima facie, my lord. Disclosed. Therefore, my lord, then all those grounds, my lord, which he has asked, I have already pointed out yesterday. My lord, that my lord will see at page 122, that is affidavit for manpower. That is relating to 4.4b, my lord, Roman 1 and 2. There's another 4.7 also we'll see. My lord, then 156, my lord, kindly see. Affidavit for equipment. I have fulfilled the argument advanced by my friend, falls flat here, my lord, has no leg to sustain. My lord, kindly come to 189 of my read petition, my lord. 4.7, which my brother was pointing out.
Page number?
189, my lord. about the bank guarantee which my brother says. He came with a loose paper. I don't know whether that is authentic or not. I don't know. It is not his fault, my lord. My lord, what will happen is, it is on 15/10/2024. 15/10/2024. In terms of, my lord, that 4.72. 8.2. No. The rejection which he says is 4.72. Which he asked. That, my lord, that bank guarantee, that extension has to be done. Now, my lord, their only requirement is to give an undertaking which comes under 4.8, my lord. Kindly read, my lord. This I have got scaled it. 15/10/2024. I understand, I the undersigned do hereby undertake that our firm MS so and so agree to abide by this bid and do hereby offer an extended bid validity for another 30 days. That is total of 120 days. 120 days for the date fixed for receiving the same, and it shall be binding on us and be accepted at the time before the expiration of that period, so and so, so and so. Well, where do I have not fulfilled? It's very sad, my lord, sometimes when we see these things, my lord. Kindly come to page 1, impugn order, my lord, kindly come again. Page 108, my lord, of my district. Now, my lord, kindly see, before I indulge my lord to page 108, I want to make one statement. My brother T.D. Nair was very right yesterday. The cat was behind my back. And exactly the situation falls here, my lord. In view of the fact that there was a caveat. Now, when the financial bid was not opened, if somebody has to come and challenge the entire tender process, it is after part 1 and part 2, then only somebody files. And what imperated them to file the caveat? That means, prima facie, there is a nexus. Prima facie, my lord. Unless if you don't apprehend that somebody will challenge, if you have done the right thing, why you should file the caveat? My lord, every time in our judicial proceeding, my lord, people tends to misuse section 148A of the CPC, my lord. They do not know the intricacies and the consequences that is going to happen. Well, that is always there, my lord. My lord, what happened normally, the objective of section 148A CPC is that once the final order is passed, then someone comes and files the caveat saying that please do not pass any order without hearing me. That is only, my lord, to fulfill the objective of adversary principle of law. In common parlance, we call it as a principle of natural justice. This is how the nexus is being proved, my lord. Now, the State Council, my lord, duty is to defend the department, but that defense must be subjected to the compliance of the equity, my lord. Equity, my lord, this word equity is not part of our constitution, but my lord, it has come from the Chancery of England. So from there we have borrowed, so the equality has come. And that equality and this principle of natural justice has come into being, my lord. That is Article 14, what we talk, my lord. So therefore here, while defending that, invoking the principle of equity, you are supposed to balance. First thing, the State Council duty is to point out whether the terms and conditions of the NIT has been duly followed by my officers or not. Here, my friend has not able to justify the action, especially in terms of clause 22.5 to 22.7. In 10 schedule, my lord, normally when we interpret the action of the speaker, there is a phrase called care timed action. That care timed action means particular time frame has to be followed. This has not been followed here. And these, my lord, I demonstrate when I kindly come to page 104 and Annexure 4, 108, sorry. Record speaks, my lord, how they have violated. Number one, my lord, date of uploading, my lord, is on 3rd November 2024 at 8:48 a.m., my lord.
104 or
108, my lord. That impugn order which I have impugned is.
Yes, you have submitted yesterday also.
Yes, you can see, my lord. Time is 8:48. Now, my lord, the official times, then normally in the court we see it's at 10:30, right, ma'am? Right, my lord. So here, before the official hours, the server was logging, my lord. And they can do this mischief. Then my lord will kindly see beat list, my lord, in the box, or kindly come to the status column, my lord. 28 October 2024. The time is 6:24 p.m. after official hours. What is this happening in this with this particular circle engineer, superintending engineer? Every tender, whatever he does is all put up to challenge in this court. Now, my lord, kindly see bottom technical evaluation summary details. It was updated on 28 October at 6:24 p.m. My lord, the part one, suppose if, my lord, 5 working days, my lord, fine. Part one you have to open on, you have opened on 15, my lord. Then it should be on 19th of October, whether it was, yes, 19th of October, let us see, my lord. 19th of October was holiday, my lord, Saturday. Then 20 was Sunday. 21 you could have done. Whereas is the rider is there. Now you have deliberately done on 28. And there is no explanation to this, my lord. Can you violate your own terms and condition of the tender to disqualify me? The answer is no, my lord. You cannot. Then what happens? The moment, my lord, they violate the terms and conditions, means there is a mala fidelis. Then what happens? Once the mala fide comes in, my lord, the arbitrary exercise of power and the biasness is proved there on the teeth of the record itself. Now, therefore, my lord, normally, my lord, my friend is supposed to file an affidavit in detail, my lord. So on this piecemeal documents, my lord, first thing, my lord, before I rely on my judgment, my lord, any judgment, my lord, I propose 2 things, my lord. The first thing is that
your respondent
private
Respondent number 6.
No. State respondent has not filed affidavit.
No. That's why, my lord, that
No, it's in the motion stage, I think.
Yes, actually, this should be motion stage. On last occasion also, I said I will produce the record. I will not able to file affidavit on today.
notice was issued already. Yesterday, therefore, yesterday notice was issued.
Actually, it should be
It
motion.
may not be possible for him to file the
Yes.
affidavit in opposition by.
I have clearly issued.
That was his, I can remember, still remember. So affidavit is not available in recording.
Well, affidavit is a must because he is.
Today, I formally assure court to produce the technical evaluation as he alleged that
Was present or not.
he has stated that the executive engineer was kept out of the technical evaluation. That was the main issue.
No,
Why?
second point which he was to come with the
No, actually, what?
Let him submit, I will let.
No, we are not on that. Now, in absence of your affidavit in opposition, do you want to dispose of the matter here? Or now otherwise it's a full hearing case?
No, my lord, if my lord is satisfied on the basis of this record, this can be disposed of. If not, I may be grant time to file affidavit, but there should not be no stay.
No,
Since,
it's up to you.
Yeah.
After your submission, I have recorded.
yes,
That may be. But the question is, do you want to file any affidavit in opposition? That is the question. Otherwise, the other private respondent is also here. He has not filed affidavit. in
Yes.
opposition. He may make his verbal submission.
now we'll file affidavit, my lord, then sort that may be given, so
No,
in that
no,
case.
That's what I'm saying, because the matter is, we are hearing the matter.
Yes.
So that's why I'm asking.
Well, let it be on 11. Let him file short affidavit because I need to see this. Let him file affidavit by today, 11, fix for admission column, we dispose of. And my.
And my lord,
Because your matters I have already recorded.
now he has to satisfy this court for
Hearing is
interim.
Almost actually completed.
Yes.
But if you want that, you want to place all these things through affidavit.
Yes,
that
we'll
can
file
only-
affidavit in that case.
Monday for final disposal, below.
We'll file affidavit.
Monday, can it be listed then?
Yes,
Monday,
Monday. I'm not taking time, Lord. Monday we'll list.
11. Let it be 12. 12.
Hmm.
Monday will file affidavit.
Monday I'll come with the judgment, I'll argue. Then till then,
That part you don't repeat because I have already.
Yes.
I have already recorded all the things.
I'll not do it. Till then, interim order will continue.
My lord, otherwise, my learned friend is somewhere moving somewhere around without coming to he has not yet satisfied the ground on which his technical bid was rejected was illegal. He has not said that. He's moving somewhere around.
That's why when I said.
Even my-
State council is not very fair.
My
Because
lord.
he could not able to justify.
My lord,
the
it was uploaded on 28th. After 28th, 22.7 says that after uploading of the part 1 bids, then there is 5 working days during which period any aggrieved party.
It's on part 1 that the.
Yeah, I am telling. Any aggrieved party who is rejected in a part 1, they can submit a complaint within 5 days, 5 working days. Here in this case, part 1 result was uploaded on 28th. 28th.
Why
Then,
not on 19? Why on 28? And you communicated me on 3rd.
my lord,
Justify this.
my friend is trying to
You don't have
says
any
that-
answer to this.
there is more than there is 5 bidders. In order to evaluate that 5 bidder detailedly, it took time.
Huh? You give
There was
reason.
5 bidders. So he cannot say that it should be why it should not be published today, why yesterday, why today, not tomorrow. That is not the ground. My submission, he did not submit a representation. His representation was submitted only after expiry of the 5 days. On 4th, he submitted representation.
Yeah.
It was uploaded on 28th. On 4th November, he submitted representation. Then on 4th, same 4th, he took authorization letter, alleged authorization. I'm not sure whether it's true or not. Authorization letter from the proprietor of the farms in handwriting,
My lord, the original
Letter.
copy is there.
handwritten letter.
I am.
Then on 5th,
Close.
he come before this honorable court by way of this writ
My
petition.
brother is settling here and there. He don't have on merits to counter my argument.
I,
He is not
I
able
don't
to-
find any ground to counter argument since you have not come to the point.
No, because you could not give
He
the
could not justify the ground which his farm his bid was rejected was unjustified.
Hey,
He
read
could not
page,
say that.
read page 122, 156,
The
158. I'm giving you, my lord. I remember this.
22.5 he has
Ground
referred.
which is-
It's also not relevant at all.
My lord, kindly see page 18.
22 point page
189, my lord.
14 and my lord may
The
read.
ground of 4.7, which he said the bank guarantee has to be validated. I have given the undertaking which they have.
No, I did not say his
No.
bids validated. I did not say bids validated. The demand draft which he submit for purchase of the tender document, it was not revalidated. I am saying that it's not bid validity. Bids validity is something different again.
No, my lord, let him file affidavit.
He filed an undertaking most probably,
Yes.
which he has.
That's 189 page. He has not read even after telling.
Which one? No,
Hey,
that I am not saying.
Undertaking was from him.
That is, my lord, with validity. With validity is something different. Heat with was valid, so its technical bid were open. I'm not saying that heat with validity was, I am saying that demand draft which he submitted, he has to revalidate after expiry of 3 months. That I am submitting. I'm not saying the heat bid was not valid. Heat bid was valid, so his technical bid was open. He's saying something, I am submitting something. He's trying to make
No.
around the things.
My lord, kindly come to page 33. 33 of the writ petition. Why he is defending the tainted chairman come SE of the bid evaluation?
My lord, it's very unfortunate, learned friend of his structure, always trying to defame the officers.
No.
Unfortunately, inter-writ petition filed against the tender process of that circle. There is no any stay order. There is, as on today, no adverse order passed by this court.
No, my lord,
So how he can blame such in such a manner?
no,
It's very unfortunate.
kindly
He has to prove his case that
page 33, my lord.
he has to stick to his case.
Page 33, my lord. The reason why
He cannot
there is
create a situation that entire process is under challenge, and
Why
because
there
of
is a
that there is some,
why
that-
there is a desperation
this is
on
very
the part of
unfortunate.
part of the state council is for these reasons, my lord. Page 33.
And repeatedly he is submitting why the successful bidders in technical suit file came it before finance. And my lord, this is, those successful, at least they have apprehension. They know the people from same areas,
No, my lord, kindly-
same brothers, they know each others,
How do you know?
and
are
they what they
friends?
are doing.
That is not your duty. It's the duty of the private respondent to make submissions.
The-
You are not supposed
yeah.
to make an inquiry that they are
And-
brothers or
And
sisters.
my friend
That
is
itself,
trying
my lord,
to,
is a biasness.
no, my friend is trying to
Your submission
impose
is-
upon this honorable court to do a roaming exercise.
submission is not
And
clear.
even the dispute,
My lord, kindly come. Page
inter
33.
submission itself is a disputed fact, which cannot, this court cannot be, even is a audio clip, it's matter of investigation. How this court will do a roaming exercise? If there is some malafide activities, then it is a matter of
Right.
investigation.
My lord, the tender,
He have made so many allegations, which is matter of allegation,
Madam,
investigation.
the
This
clause-
court cannot interfere itself.
my lord, class 22.5 to 22.
Litigant cannot expect court to do robbing exercise.
First part, he has not complied with. Primarily, only because they have been violating the own tender norms, page 33, my lord, kindly see. It was to be completed on 24th month, 7 years, 10 PM, that part 1 was to be opened. 24 July. He has not done it.
My lord,
And
there was
thereafter-
another writ petition pending. There was a petition before disposal of the representation submitted by the that petitioner. This tender process was not supposed to open. Only after withdrawal of the representation, only this tender process. There was a circumstances situation why this it was not open.
Well, sometimes
That Inam Yangpo versus other.
Most of the half part, not half part, almost, the hearing is completed, but you file your affidavit in opposition, that should be in the record, in fact.
Yes.
And if you want, you can also file the private respondent, and we'll hear the matter on 11. We'll try to-
11, but not for final disposal, without any
Well,
adjournment.
maybe at least on 12.
No, let it,
12
let it
cannot
be
be-
11.
Monday, it will be thought a little bit difficult.
You come,
Today,
you come on 11, let us do it.
no,
When I'm saying-
I am ready, but 11 will file, 12 will have. That I'm sorry.
No, if you file on 11, then the question is that you'll be ready and filing it up. It is his duty to peruse your this affidavit and all. So if he is also ready on 11, it can be hard.
Actually, I have some personal difficulties. By tomorrow, if there is no matter, I am ready to move somewhere out of the station. That is difficult.
But by 11, will be able to file?
Yes, I will, on Sunday I'll come back, Saturday I'll come back, and Monday I'll file.
There is no worry for me. I have heard his argument. Normally, my lord, God has given me one thing. The moment any of my friend realize any documents, almost half part is in my mind.
Okay, you are.
That different case.
So
That is
therefore,
not relevant.
therefore, my lord, all his submission I have heard,
He has a computerized brain. that's
I have memorized, and all his documents, whatever, my lord, he, my lord, in the court proceeding, you cannot, before the judge, honorable court, you cannot give this document, you take this piece. No, it should be in a proper format, so that, it brings on record, so that there is a proper dispensation of
No,
justice.
that's it, no. Most probably Tarak, he asked me some more time to file the affidavit in opposition, but subsequently he told him he's going to produce these documents. So that may be the reason why he has produced. Otherwise,
My lord, I'll not seek any adjournment. 11, it should be finished.
I don't know, 11, can it be?
Not.
Okay. So by 11, you file your affidavit also, because today is, tomorrow is one left, I think. Monday, 11.
That is why I'm seeking for 12.
Your lordship, my small prayer will be, this stay may not be continued. I may not be suffer. Because I meet up all the requirement.
He is seeking for early disposal. So if you are ready by 11, then will be hard, or if Mr. Tara has some kind of difficulty on 11, then make it on 12, but.
There is no allegation against him, my lord. There is absolutely in the read petition, my lord.
If required,
no
I will file.
allegations.
If required, I will
Oh.
file affidavit.
That-
12 will be minus 12. 12 will appropriate.
If he has some
For-
problem, make it on 12.
Final disposal.
Yes, 12 for-
Because, my lord, in tender process, my lord, I also agree. But only my worry is, there is a prima facie arbitrary exercise of power.
It's on 12, and I will be, also Mr. Tara, for the state respondent to file this affidavit in opposition. And interim was there, interim be continued. till the
Continue.
state of this state.
Grateful.
And the shall be made to dispose of the matter.
You keep this in this.
Okay, we'll try.
Grateful.
Okay.